Welcome to this Extreme Belief lecture in the Extreme Belief series. It's fantastic to have our speaker today, Ms. Jennifer Lackey. But before we get started, let me say that we do these lectures regularly, so once every month or once every 2 months. Usually they're also recorded. So if we miss part of it somehow, or to look back at an earlier one, you can just go online, go to the website www.extremebelief.com, and you will find them there. So let me briefly introduce our speaker for today. Professor Jennifer Lackey is the Wayne and Elizabeth Jones Professor of Philosophy and also Professor of Law at Northwestern University. Also founding director of the Northwestern Prison Education Program, which takes at least as much time, she told me earlier today. And also a senior research associate at the Center for Technology and Philosophy of Science at the University of Johannesburg in South Africa. Her primary interests are in social epistemology, and she's written more than 60 articles and 3 books, including this one. I couldn't bring all of them, but the epistemology of groups, you probably all know. And lately she's been working mostly on the American criminal legal system. Extremely topical, we would all agree. She's also the editor of 5 volumes and editor-in-chief of 2 well-known journals, probably submitted materials all of us or most of us, so epistemic and philosophical studies. She is the winner of the 2024 Humanitas Award, the 2023 Horace Mann Medal, the Leibniz Prize for Philosophical Achievement and Contribution, and she was elected president of the Central Division of the APA in 2021 to 2022. She has received grants and fellowships from the Guggenheim Memorial Foundation, the Mellon Foundation, the American Council of Learned Society, and the National Endowment of Humanities. And she currently holds the Spinoza Chair at this other university in the city. There's another one, in addition to the Vrije Universiteit, which is the University of Amsterdam. May I say it is fantastic. It's a pleasure and an honor to be with us today, and we look forward to your lecture.
Thanks so much. Thanks so much for having me. It's really a pleasure to be here, and to be out of the United States for a period of time. What I'm going to be talking about today is a chapter in a book project that I'm actually hoping to finish up within the next few weeks. And so there will be probably, basically the point is I'm happy to kind of contextualize some of this a little bit more during the Q&A, because I think that, there's a chapter that comes before it and 3 that come after it. So I think that, some of the issues that I'm going to bring up, I might not be able to go into in tremendous amount of depth. So I want to talk a little bit about the role of storytelling. I'm going to be using storytelling in a very, I'm not using this in a technical sense. And I'm going to use story and narrative pretty interchangeably. And I'm not going to be using these notions there's, all sorts of theories about kind of conditions that narratives need to have and stories need to have. And I think broadly speaking, the sort of ordinary notion of storytelling that I'm interested in oftentimes has those features, but I'm also really interested in things like labels and, I'm happy to either call that like a mini story or the chapter of a story. So I'm not, the nature of storytelling and the nature of narratives is not really that crucial to me. I'm just going to work with a very intuitive notion, but I'm really interested in the way that stories kind of epistemically wrong people. And the book project that I'm working on is on epistemic reparations more broadly. So it's also looking at the kind of storytelling that can also engage in the appropriate epistemic reparations. So the broader context of the project is that I'm really interested in gross violations or injustices. And so why am I interested in that? It's because in the first chapter of the book, I contextualize the project within a report that the UN Commission on Human Rights, they issued the report in the 1990s, but updated it in 2005. And it talks about the rights that survivors of gross violations or injustices have, one of which they characterize as the right to know. So for instance, if there's a genocide, then, people have the right to know where the bodies of their loved ones are buried, whether there was state involvement and so on. And one of the big kind of conceptual moves that I make in the book project is to argue that the UN should recognize not just the right to know, but the right to be known. And then I spend a big portion of the book characterizing what it means to have the right to be known and how we fulfill that right. Okay, that's kind of big picture of the project. And so I'm interested in the ways that storytelling distort our knowledge of other people, or conceal our knowledge of other people, or falsify our, prevent us from knowing other people and that sort of thing. Okay, so that's kind of where I'm going to be picking up. So the stories that are told about others can rise to the level of inflicting gross violations or injustices themselves. Why is that significant? That's significant because I only think that epistemic reparations are owed in cases where there's a gross violation or injustice, either where there is a moral gross violation or injustice that gives rise to an epistemic wrong, or in this chapter, I suggest that certain kinds of stories can themselves rise to the level of a gross violation or injustice that is demanding of epistemic reparations. Okay, so let's get to it. So I'm going to use the criminal legal system as a paradigmatic example. My area of specialization is in the American criminal legal system, so I'm going to restrict myself. I don't know all the criminal legal systems, and I'm going to be using it as a paradigmatic example of how I think storytelling can rise to the level of being a gross violation or injustice. This is not, the thesis is not that the American criminal legal system contains stories that rise to the level. This is an example, an instantiation of a bigger thesis. I think that there's many other cases like this. It's just that I think it's a pretty powerful one, and it's one that, kind of, I can tell this story because I know this material well. So to start with, storytelling plays a really powerful role in nearly every aspect of the criminal legal system. So, there's lots of legal scholars that talk about kind of just the nature of law arising from storytelling. Here's a legal scholar arguing that the law itself is derived from the sacred narratives of our world. Trials are often also regarded as kind of just being venues for storytelling. So Samuel Gross, another legal scholar, writes, "It is commonplace that most successful courtroom advocacy is structured as storytelling rather than logical proof." Another legal scholar writes, "It is narrative itself that determines a trial's outcome." So when someone says that, what they mean is to distinguish this from the view that it is really the probative force of the evidence that is actually doing the work with respect to verdicts in trials. There is this view, this narrative view, that says actually it is the features of the narrative, the storytelling. Let me see if I have a slide. No, I don't have a slide. There's just so much information that I don't have enough time to go over. But for instance, there are features that are regarded as being good stories, coherence and the completeness of being able to account for those factors. And there's not only, kind of theories that say that that's really how jurors reason to a verdict, but there's also empirical evidence that shows that this is actually, in fact, what jurors in, at least again, the American criminal legal system do. And yet, despite the role that narratives play in the criminal legal system, defendants themselves rarely have the opportunity to use their own voices during the legal process. So legal scholar Alexandra Natapov expresses this point powerfully when she writes, "The United States criminal justice system is shaped by a fundamental absence. Criminal defendants rarely speak." And so this is the result of a lot of factors, including, for instance, that trial by jury is on the verge of extinction in America, with 97.4% of felony federal convictions in the United States obtained through guilty pleas, and state felony convictions not far behind. I think every single state felony conviction in the United States is probably hovering around 93 to 95. So there are not outliers. And even when defendants go to trial, they're often discouraged from taking the stand to avoid, for instance, aggressive cross-examination and prejudices and biases and so on. So against this background of silence, there's an area in the criminal legal system where defendants seem to have a very robust role to play in their own destinies, and that's at sentencing hearings. So the right of allocution permits a criminal defendant to speak at his own sentencing hearing prior to the sentencing itself. And the importance of this right is clear, says Berger Kaplan. In a system where so few people go to trial, let alone testify, sentencing is often the only opportunity for defendants to speak during the legal process in a way that is even nominally unconstrained. But I want us to stop and I want us to think a little bit about how the sentencing hearing, being able to exercise the right of allocution works in the case of an innocent defendant. So I'm going to talk a bit about, as a case study, someone that I've known for a long time, Demetrius Cunningham. who is still incarcerated. So at the age of 15, Demetrius was interrogated for several hours by Chicago police officers. He was actually originally brought to the police station by his father to view a lineup of suspects. So his father willingly brought him to the police department, thinking that he just he was thought to have information about a suspect. After he didn't pick out the person in the lineup that the police expected him to, he was taken into a room by himself while his father actually was sitting in the lobby, completely available, and interrogated by 3 white police officers for hours. At the end of the interrogation, and they used I've discussed this extensively in my last book. There's all sorts of tactics that are used in the American criminal legal system to extract testimony from people, extract confessions, false identifications, recantations. There's just a method that is often used. And especially a juvenile like Demetrius was, are very susceptible to basically providing whatever testimony they think the authority figures want. And so at the end of the interrogation, Demetrius falsely confessed to murdering an elderly woman in the Loop and was sentenced to 85 years in prison. He is still incarcerated. Okay, so for a defendant who is innocent, you might think that the right of allocution would be a space. Okay, so imagine you're innocent, you go to trial, you're found guilty. Okay, you might think that the right of allocution is a space where you can finally get, kind of your narrative out there because you've been silenced, kind of through the entire process. As Kimberly Thomas, but this is actually not how it works in the criminal legal system. Kimberly Thomas, another legal scholar, writes, "Courts do not want to hear allocution stories of innocence. Most judges assume, often consistent with the evidence they have heard, that the person before them actually has committed the offense and any innocence tale is fiction." Now, the mere fact that courts silence innocent defendants and their allocution stories we might think is problematic by itself. So consider the perspective of an innocent defendant like Demetrius, who has just been wrongfully convicted. The only point he's spoken in the whole process may have been in the interrogation room when his confession was coerced. After that, he may have been found guilty at trial because of the massive weight that was afforded to his false confession. And in all of the proceedings since the confession, he has been silent, he's been spoken for and about, but never heard from by the court through his own in real-time voice. So he arrives at the sentencing hearing, he's aware that it's his final opportunity to make a case to the court for justice and mercy, and now he's told that no one actually wants to hear that he's innocent. But the violation doesn't stop there, because in addition to being silenced, the defendant is then essentially provided with a script of what he should say. So judges have archetypes of ideal allocutions in mind. They want the allocution to express genuine remorse, sincerity, realistic and concrete plans for the future, an apology to the victims, an understanding of the seriousness of the offense. So the innocent defendant is not only told to swallow the truth and to eat his cries of innocence, he's also handed a script of what he should say to the court. More perversely, he's told impossibly to be both sincere and yet to express life-shattering and identity-destroying falsehoods. So he should somehow feign remorse for a crime he didn't commit, one that's often for him unimaginable to have committed, and to utter words that are in the shape of an apology but have no authenticity because he can't be truly sorry for doing something he didn't. And then there's, it's kind of pretty well documented that those who fail to follow the script, the script, kind of this sort of, de facto script, risk and receive harsher sentences. So there are oftentimes judges who will actually say, I was going to give you this amount of time, but now actually hearing this, I'm gonna go for the maximum. So while storytelling plays a powerful role in human lives, especially in the American criminal legal system, we see that defendants rarely have a voice in their own narratives. And this especially impacts innocent defendants who are silenced when telling the truth and given a script to follow that's foreign to who they are and fracturing to their moral identity. But they also then suffer life-altering consequences, such as additional time incarcerated for any form of resistance. So the violations and injustice that are inflicted on a person through a wrongful conviction, of course, are deep and multifaceted. In addition to the horrors of being convicted and incarcerated for a crime he didn't commit, the official story about him that's cultivated, extracted, and promoted by the state is often unrecognizable and demonized or vilified. This is one of the students in the program I direct, Scotty Miller. I think he makes this point really powerful when he writes, an extracted false confession creates a false narrative of that person's life. In other words, the extracted confession turns a person's life into a lie. That lie is then believed over the truth of that person's life, victimizing him over and over again. This seems to be the ultimate crime, stealing the essence of someone's life while they yet breathe. One of the reasons I think this quote is so powerful for the sort of point that I'm making is that Scotty is specifically talking about the violation of the narrative, right? Not, I mean, of course, he's currently incarcerated. He's sitting in prison. He's wrongfully convicted. He's deprived of contact with his family, and so on, right? All of the things that kind of deprivation of freedom brings. But here he's talking specifically about the additional violation of the story. So justice requires not only material reparations, including release from prison, exoneration, and financial compensation, but also what I told you are epistemic reparations. I don't think I give it a definition of that. I'm happy to go over that in the Q&A. It's just that, this is part of a bigger project, and I'm not going to have a lot of time to go over all that. The state's false story inflicts an additional violation and injustice on a wrongfully convicted person, one that demonizes and distorts who he is and often who he can become. So one way of engaging in the epistemically reparative work that's required is through replacing a false or vilified narrative of a person with a true and respectful one. Consider, for instance, Hilda Lindemann Nelson's notion of a counter story, which is a story that resists an oppressive identity and attempts to replace it with one that commands respect and positions itself against a number of master narratives. Now, Nelson's central example is of a counter story of a group of nurses. So she's really interested in these kind of master narratives of like women, right? And then kind of nurses weaving together this sort of counter narrative that is, counter to this master one. But I think that we can even imagine counter stories of even a single person's life, like Scotty's or Demetrius's, doing some of the reparative work that's required. So this is Demetrius now. This picture was probably taken about a year ago. So extending Nelson's concepts, we can understand the master narrative of Demetrius's life being the one that was created and promoted by the state. That Demetrius murdered an elderly woman, that he lied about his own actions, and that he failed to have the appropriate normative responses of taking accountability for his actions and committing to repairing the damage he caused. This narrative exerted a tremendous amount of epistemic and moral power over the community. It enabled them to make sense of their experiences of, say, hatred for Demetrius, to justify incarcerating him, to constrain their imagination over how he deserves to be treated, and so on. The reparative counter story of Demetrius resists this false narrative and replaces it with one that is accurate and restorative of his status in the community. It not only makes clear the truth about his innocence and the grave injustice he faced through being wrongfully convicted and incarcerated, but also the duty we have to know him for who he truly is. This picture, I think, is quite like a remarkable picture because here he is at a conference that we hosted inside the prison. It was a philosophy conference. So I think Miranda Fricker was there, Jose Medina, Sandy Goldberg talking about his false confession. So it's kind of really a remarkable moment. The importance of this particular epistemically reparative work is made even clearer against the background of empirical work on wrongful convictions. So according to a systematic review of research, the impact of being wrongfully accused of a criminal offense is seen to be frequently complex and long-lasting, with participants reporting permanent changes to their personality, being less confident and more mistrustful, a loss of dignity and credibility, a loss of hope and purpose for the future, a loss of their pre-accusation self, damaged reputations or feeling stigmatized by others, feeling that their standing in the community had been affected negatively, and feeling labeled and vilified by others. Crucially, for our purposes, the authors note that it was particularly difficult for participants to regain their previous sense of self if they received no formal apology or public statement of innocence, effectively delabeling them. I think this is a clear and compelling acknowledgement of the importance of what I call epistemic reparations. Without a counter narrative, the victims in question are left not only with the stigma and loss of standing within their community that comes with a wrongful conviction, but also with a damaged sense of self that impacts who they are and who they can become. But crucially, harming or wronging another person in a way demanding of epistemically reparative work, especially through storytelling, does not necessarily involve having false or even unwarranted beliefs about him. So consider the phenomenon that I call misknowing, where only a narrow, one-dimensional set of facts are centered about a person or persons, often focusing on those that are most injurious. Misknowing is a form of knowing, because it involves just, kind of justified true beliefs or whatever, whatever the analysis is, but it obscures as much as it reveals. So there are many versions of misknowing, but here I'm going to focus on cases, perhaps unsurprisingly, given my other interests, where someone is in fact guilty of a crime, but we reduce his entire identity to this one action and regard him as nothing more than, for instance, a murderer or a rapist. So meet William Peoples. William admits that he murdered his neighbor in a burglary that went terribly awry in May of 1988. Today, well over 3 decades later, he's a deeply valued member of the community of the program that I direct. He mentors those in need. He lifts up those around him, lives an exemplary life of love and service, and made history as one of the first incarcerated students in the United States to receive a bachelor's degree from a top 10 university. To know William through the lens of only one, albeit true, action in his nearly 6 decades of life is to misknow him. It is to center one moment in his full, rich life and to relegate features that are now crucial to his identity, such as student, friend, published author, mentor, and visionary, to the margins. One thing that's sort of remarkable is that this picture was taken at the prison that our program used to be in, but the governor has since closed it. But that building behind us was the last panopticon that was being used for people. It was closed in 2015, but prior to that point, it was the only panopticon in the world that people were housing people in. I mean, the prisons were housing people in. So misknowing William allows this one truth about him to squeeze out knowledge of other deeply important truths about him as a person. So what I'm going to try to convince you of is that the forces that shape the public narratives of Americans with criminal convictions rise to the level of being a systematic injustice. Okay, so we already talked about sentencing hearings for innocent defendants, but at a sentencing hearing for a guilty defendant, we also see something somewhat similar. So the guilty defendant is also likely to be silenced or coerced into following a script provided by the court. He may, for instance, quite reasonably feel that it is inappropriate and inauthentic to just simply admit guilt, express remorse, and apologize. A guilty defendant may have ended up in front of the judge for countless reasons, including in large part because he's poor or uneducated or profiled because he's a Black male. He may feel that he has been victimized himself by many people and systems in a multitude of ways. The defendants that were interviewed in the research by Berger Kaplan, one of them expresses this point pretty powerfully when he says, look, it's tough, right? Because it's like, it's a desperate ass time and people are probably going to say anything that they can say. It's like, shit, somebody has a gun to your head and, tell me what you want me to say. And so the defendant is saying basically like, I'll give you whatever you want. I'll give you whatever testimony you want. So as it notes, I think the desperation, kind of leads people to just leads them to just admit guilt and apologize, even when this is entirely, as we saw in the case of Demetrius, or largely, as might be the case in some others, unwarranted. These scripted and coerced allocutions not only contribute false and distorted content to the public narratives of criminal defendants in America, they also lend legitimacy to them. If even the defendant himself admits guilty and shows this much remorse, we are clearly getting things right. One of the things that's really kind of extraordinary, I mean, I have so many things I want to say, but I need to be really mindful of time. But I also look in some of my work at how these scripted and coerced narratives are also required at parole hearings and at clemency hearings. So I myself end up testifying at a lot of clemency hearings because I work with so many people who are decades into their incarceration. And so a clemency hearing is asking asking the state for mercy. And so a lot of people go up for clemency, kind of after many years. But one of the things that's really striking is that the state will oppose, I mean, in every case I've ever testified at, quite literally every single one, if the person who's asking for clemency says, but look, I was actually wrongfully convicted from the outset, the state will show up and oppose it, right? Because the person hasn't grown. They're still denying it. Right. And so they just haven't been rehabilitated. And so one of the things that's really remarkable, and I'm not using this in a positive sense, is that the criminal legal system is sort of set up so that the narrative that is extracted in the in the interrogation room is spit back out to them before they ever leave the doors, right? Because you have to sort of regurgitate the same narrative of guilt before they will let you out, right? And so it kind of preserves, kind of what this appearance, right, of legitimacy, right? Because there is no sort of counter narrative in the books, so to speak. The media also contributes to the distorted images, labeling, and stories of many criminal suspects and defendants in the legal system. I'm not going to spend a lot of time on this. I assume that you all are familiar with at least some of this, kind of the role of the media. But here's just a couple of, like, from a recent report. Looked at it found that mugshots were used, for instance, in coverage of 45% of cases involving Black people accused of crimes in America, compared to only 8% of white defendants. White victims were also nearly 4 times more likely to be presented in photos with friends and family than Black people victimized by crime. The report also found that more personally descriptive words were used for white defendants rather than for Black. So white defendants, for instance, were characterized as a father or a son or a man, or I don't know if this was popular here, but the Stanford swimmer. Did you guys hear about that? Okay. Anyway, these are some of the, these are some of the labels that are used for white defendants, whereas for Black defendants, kind of much more, reductive label. Like one of the examples is, serial killer and that sort of thing. As the report notes, the exclusion of a defendant's name, particularly in favor of a label like serial killer, is yet another way we see defendants, especially Black defendants, dehumanized and reflexively criminalized in coverage even before trial. And this dehumanization is exacerbated by the fact that quotes from family members and friends were nearly twice as likely to be found in articles about white defendants. So again, giving them kind of this narrative, right? This kind of, Moreover, many aspects of the United States result in people who have been convicted of a crime having their identities largely reduced to this one act. For instance, while crimes, especially high-profile ones, are often heavily covered in the media, rarely do we see similar attention paid to the accomplishments or virtues or growth of people who are incarcerated. And so this results in the publicly accessible narratives about incarcerated people often being limited to only their criminal activity. We see the mugshots of people who are incarcerated rather than photos of them in classrooms or hugging their children during visits. We read about their possession of a gun rather than their publication of a work of poetry or their leading a restorative justice circle. In addition, prisons are often geographically isolated. Some scholars call prisons in America occupying the geography of nowhere, because they oftentimes are in rural communities so that the institutions and the people inside of them are rendered invisible to most of the public. Their communication is highly restricted and monitored within carceral settings so that incarcerated people have very few options for having their own voices heard beyond the bars of their cells. All of this contributes to a systemically driven, unwarranted focus on only the criminal acts of incarcerated people in the United States. This in turn leads to them being vilified and distorted as nothing more than, for instance, a cold-blooded murderer or a monster. So the misknowing of suspects and defendants is often caused, fueled, and exacerbated by the stories that we tell about them. Despite the powerful space that narratives occupy in the criminal legal system, defendants, whether they are innocent or guilty, rarely play even a marginal role as authors of their own public stories. They're silenced, they're handed a script to follow, and punished severely for failing to follow it. They are then vilified and distorted by the media. They're relegated to isolated carceral settings that are under nearly constant surveillance, and they're afforded very few avenues for communication with the outside world. This results in these images and labels and narratives developed and promoted by the criminal legal system and the media, socially locking defendants into these stories, sometimes for life. So just as a wrongful conviction requires a counter story as a form of epistemic reparations, so too I argue that misknowing in the criminal legal system requires what I call a rounder story as a kind of epistemic reparations. E.M. Forrester's famous distinction between flat and round characters is a foundational lesson of many writing courses. So flat characters, according to Forrester, are static and constructed around a single idea or quality, with none of the psychological desires and aches that complicate even the most consistent human lives. Other people characterize flat characters as endowed with one or very few traits, highly predictable in behavior, monochromatic or one-dimensional, often cast on stage to express a single idea or to serve a specific plot function. They may have some aspect or trait that makes and keeps them interesting or compelling, but what they lack typically is psychological complexity or the ability to change. They are fixed entities and typically do not develop or change in the course of the plot. Round characters, in contrast, are dynamic, complex, and multidimensional, with sufficient information conveyed about their internal tensions, contradictions, and complications, so that their actions are understood as the product of several different drives or conflicts derived from more than one level of their personality. In addition to this psychological complexity, round characters are not static, and they evolve or change internally as the plot develops. I extend this distinction between flat and round characters to apply to stories themselves and to the resulting knowledge that's conveyed. So I understand a flat story as one that depicts a person in static, one-dimensional, and psychologically simplistic terms, and the knowledge that is then conveyed about him is correspondingly flat, while a round story is one that portrays a person in dynamic, multidimensional, and psychologically complex terms, and the knowledge that is then conveyed about him is correspondingly round. As should be clear from what was developed above, many of the stories that are told about criminal defendants, especially when they are Black, are flat. The media, for instance, center on the one day of the crime, depict the person in a mugshot, avoid the use of his actual name, and label him as the accused or a serial killer. The criminal legal system then provides virtually no avenues for the defendant to tell his own story in his own words. Once this story of a person's life is created, told, and promoted, the defendant who is convicted is then locked away in an American prison, often in a rural community, with their public narrative similarly locked in time. As far as most of the world knows, he will always be nothing more than that one awful day of his life. This is a paradigmatically flat story where a person is depicted in static, one-dimensional, and psychologically simplistic terms. This misknowing connected to flat stories also often begets further downstream epistemic consequences. Flat stories are often massively impoverished. They lack backward-looking information, painting a dramatically incomplete picture of the person's past, leaving out highly valuable information that would help understand his motives, actions, and character. For instance, William Peoples, despite the fact that, he absolutely admits that he did commit, he did murder his neighbor. When he was a young man, he had been falsely accused of raping a white woman. And his public defender said, look, you're a young Black teenager, and you should just plead guilty, because if you go to trial, you're going to get, you're facing decades. And so he pled guilty to a crime he didn't commit, went to an adult facility, and admits that he came out of prison a very violent person, because, spending time in a very violent environment as a young person growing up there had a very significant impact on him. That's backward information that is just left out of the allocution when you just follow the script. There's also present information, including about the person now. It's also distorting, often including labels that are vivid and powerful and swamping, such as murderer and rapist. And the combination of the knowledge being impoverished and distorting then gives rise to future-looking inferences and conclusions that are false and misleading. So again, the flat story told about William, we know this, it portrays him as static. So one of the ways I try to characterize this sometimes is I talk about how flat stories are they're reductive, they're one-dimensional, but they also kind of are agentially closed, and that's sort of the static part of it. So this is often thought about like, you're a murderer, you're nothing but a murderer, and you always will be a murderer, right? And so it's agentially closed, meaning there's nothing there are no agential possibilities open to you kind of for having a rounder life, for kind of any form of redemption. And that really is all you are. That is all that is kind of salient about you. So what might such a rounder story look like if William Peoples is owed one? Just as the exonerees in the study cited above report that their sense of self cannot be restored without a counter-narrative delabeling them, so too many people swept up in the criminal legal system need a rounder narrative delabeling them, even when they are guilty of committing the crime in question. And so, I think that this is pretty easy to see. So in the report discussed above on the role of racial bias in the media regarding coverage of people prosecuted in the criminal court system, the authors provide recommendations for the media, some of which provide minimal guidelines. I would say they don't use the language of round stories, but I think these are oftentimes minimal. I think one way of understanding what they're getting at is that these are minimal guidelines for rounder stories in the media. So they suggest foregoing images that drive perceptions of guilt, avoiding labels that carry negative connotations. In particular, they write that reporters credentialing defendants by crime is dehumanizing, and that journalists should provide quotes from family members, friends, co-workers, and community members so that they do not remain singularly associated with the offense with which they have been charged, especially in the case of Black defendants. I regard this as an explicit call for rounder stories in the media of covering defendants in the American criminal legal system. Now, importantly, there is frequently an epistemic connection between the subject of a flat story and the beliefs of the teller or holder of it. To oversimplify with a slogan, when I epistemically harm you through a flat story, I often epistemically harm myself too. A brief discussion of a few well-known cognitive biases can help illuminate this. The anchoring bias involves the tendency to rely too heavily on one piece of information or trait, with this anchor often being the first piece of information acquired on the subject in question. A close neighbor is the salience bias, which involves the tendency to focus on information that is more emotionally striking or prominent, even if it is not the most important or accurate. So suppose, for instance, that the first fact a community leader learns about William, or the most emotionally striking one, is that he murdered his neighbor. Even if the context is such that this is not the most important event in his over 6 decades of life, perhaps the discussion at issue is regarding his academic record, it may nonetheless anchor the community leader's judgments about him. She may focus on or gravitate toward this one fact, remember only it, and overemphasize its significance. This can then lead to or ground the formation of false beliefs and erroneous judgments. For instance, just as a person who recently witnessed a hurricane may overestimate the risk of this happening to her, the community leader who knows only this fact about William may overestimate the risk of him engaging in violence in the future, despite ample evidence to the contrary. Or just as voters may respond to an emotionally charged news report of an immigrant harming someone to arrive at a decision about immigration policies more generally, this one event in William's life may sway people's views about his employment opportunities, even if there are no corresponding arguments in support of them. Appealing to, but he's a murderer, to form judgments or persuade people when it is irrelevant to the question at issue not only leads to epistemically unwarranted conclusions, it also provides a centrality to this fact and knowledge that is distorting and misleading. This can then lead to tunnel vision, which, we all know involves heuristics and logical fallacies that focus on a particular conclusion and then filters all of the evidence through the lens provided by that conclusion. Through that filter, all information supporting the adopted conclusion is elevated in significance, viewed as consistent with the other evidence, deemed relevant and probative, and so on. Once the fact that William took the life of another person is an anchor in the community leader's cognitive framework, she may filter everything else about him through this lens. Evidence of any sort of conflict while he's been incarcerated may be elevated in significance or taken to support the flat story in question, while evidence of growth and transformation may be reinterpreted or dismissed as deception and manipulation. Consider also the fundamental attribution error, which is the tendency to prefer or overvalue dispositional explanations of behavior, such as a person's personality traits or character, and undervalue situational explanations, such as the context in which the behavior occurs. For instance, rather than looking at a defendant's drug use or the financial desperation of his family to explain him robbing a gas station, there is a tendency to instead see him as a violent or deviant person. Perhaps unsurprisingly, this has a host of negative consequences. With respect to the criminal legal system in particular, dispositional attributions can lead to investigators and juries engaging in racial profiling when initially encountering witnesses and defendants. And studies show that how crime is explained directly affects beliefs and policies about legal and social responses. When a defendant's behavior is attributed to his circumstances, judicial officials are more likely to advocate for rehabilitation than punitive responses, whereas when a defendant's behavior is understood as the result of internal factors, he is regarded as dangerous or treatment resistant. While the community leader's acceptance of the flat story of William as nothing more than a murder vilifies him, renders who he is today invisible, damages or destroys his epistemic relations in the community, and stifles his epistemic agency and future possibilities, she also harms herself epistemically. She forms false beliefs, missing out on knowledge, failing to deepen her understanding of important matters, and closes off areas of inquiry. There was a 2020 article headline that read, "How the Media Created a Super Predator Myth That Harmed a Generation of Black Youth." 25 years ago this month, the word super predator spread in the media like wildfire, shaping criminal justice policy for decades. In this analysis of super predator, the analysis tries to explain how this happened, how this flat story of young people engaging in criminal activity ended up kind of taking over policies that continue actually in the United States. We continue to have policies right now that still kind of emerged from that conception of that's long been debunked, but where the policies remain. So the analysis that is given, I mean, again, this is all put into the framework that I just gave you. I'm not suggesting that the people who gave this analysis are using these terms. So the media embraces what I am calling a flat story. Okay, so the media embraces a story that there is a very simple explanation of why a young person committed a crime, and that is because he is a super predator. Okay, a super predator is a characterization that does not have anything to do. It has to do with the attributions of the person himself, not his circumstances. Right? It doesn't kind of look at kind of whether there was poverty in his household or whether there was an incident that occurred. It just is. This is just who you are. Okay, so the media embraces not only a flat story, but a flat story that essentializes the person, right? This is who you are. And it also, super predators were regarded as kind of not open to rehabilitation. So it's a kind of a classic, it's in a way a classic flat story, what I'm talking about, right? That it is this person is a super predator. They will always be a super predator, and they're nothing more than a super predator. That's just what they are. Then the analysis said that the media, when they embraced it, then started kind of sensationalizing it by kind of using this label to characterize, kind of, all the stories that were to come. Okay, so providing this flat narrative over and over and over again. And then when this kind of became just the dominant narrative or the master narrative of young people engaging in criminal activity, policies were enacted that, kind of still contribute to mass incarceration in the United States today. So that is one of the ways in which I think that the flat stories and the stories that we tell contribute to extremist beliefs, and the extremist beliefs in turn ground policies that destroy people's lives. So through stories that are both false and flat, people can be wrongfully thought to be who they are not, either because they are not even the proper subject of the narrative in question, or because they are so much more than how they are depicted. At the same time, we have the power to engage in the epistemic reparations called for in such cases through the creation and promotion of stories that counter or round out those who are responsible for the wrongdoing, those that are responsible for the wrongdoing. In this way, though the narratives that we create and share can quite literally shape who people are capable of becoming in life-destroying ways, they can also be the path forward for holding one another in life-restoring ways. That's it. Thanks.
Thank you so much. We've got 45 minutes for questions and answers. So who would like to go first? Anya, why don't you go first?
Thanks so much. This was incredible and very sad. Well, so it's hard to be a philosopher when you hear something. So my question is about whether you think if there's any utility in applying the concept of misknowing and flat stories to not the people we villainize, but the people we idolize. So there's been like a string of documentaries on religious cult leaders that we thought were incredible people, and ended up being implicated in sexual abuse and so on. So it's really hard to deal with that because they've impacted people's lives in such a tremendous way. There's this positive impact in the world, normal for you. So if we're just reducing them to, I think, like an idol, are we misknowing?
Yeah, I think that's a great question. So when I first tried out the concept of misknowing, I think the very first time I tried it out, I think was at a conference in Glasgow. And I had built in that the beliefs were injurious into the definition. And that audience like immediately convinced me that the concept of misknowing is probably more useful and doesn't have to, you don't have to build it in when it's more of a generic notion. And I think that that's right. So I was convinced of that. And I think that your example of idolizing is a really interesting one. So the reason I originally built the negativity into like that it's an injurious story is because my book, what I'm really interested in is gross violations or injustices that require epistemic reparations. And so I'm interested in when you are the victim of misknowing, you are owed epistemic reparations. A lot of these other cases are much more complicated, right? So the example that the audience member in Glasgow used was, what if you just center about Christopher Columbus, that he sailed the ocean blue? That's it. There seems to be like a case in which like you're crucially misknowing Christopher Columbus, right? By that. That seems right to me. I really like your example as example of idolization. And I think that I don't have a framework for thinking through what I want to say about that. I think it's a very provocative question. And I think that there's a lot to be done there, because I think that what's going to happen. And again, I'm trying to stay singularly focused on finishing the book. Like I'm weeks away. And so I'm trying to not like, you know what I mean? Literally, because it's like, this book could be 6 times the length, you know what I mean? But you're the first person who has asked me specifically about the idolizing. And I really like that example, but I've been asked a version of this kind of a lot. I'm inclined to think that there's going to be an analysis there that is going to involve the impact of misknowing in the positive cases and the injury being to other people and, to other community, it being sort of an interpersonal injury. What I'm really interested in this project is where the misknowing injures the one who is misknown. Those cases. Now, there might be some like superficial ways in which when you're idolized and you're misknown, you're injured. But I think that probably what happens in a lot of these cases, like the Christopher Columbus case, is that the misknowing brings about other sorts of problems. Yeah.
So much.
Mhm.
Your next, can you please speak up so that the people at home can hear it as well?
I will.
Good.
Thank you very much for this super interesting talk. And I have a background in law as well, so I was triggered a lot and I really liked it. I was immediately thinking about similarities in the Dutch legal system. We don't have jurors, and a guilty confession here is not enough for conviction of murder or any high degree of criminal offense. So I was thinking, how should we see the generalization of this framework? Should it always be about gross injustices, or can it also be about maybe more milder injustices that the stories do? So I'm working on multi-level marketing companies at the moment, and the belief systems that they bring with them. And the story about M&Ms is, it's just for grandmas who sell Tupperware to each other who have a reason for a party, whatever. Right? That's a very big story, at least in the US. So I was thinking, does this framework also generalize to, maybe less gross injustices, but yeah.
So I'm going to give you structurally, my answer to you is going to kind of mirror a little bit. So, because so the project here, no. So the project here is really starting as very intentionally with the UN document, okay? Because I want the notion of epistemic reparations to be a politically and legally weighty notion. When I say epistemic reparations, I mean it. Like, I don't mean like epistemic repair. Like if you tell, like if you're, so I get questions a lot, like, your partner has a false narrative about you, or your friend has, do you owe them? I would not use epistemic reparations in those contexts. I tend to think of epistemic reparations as typically involving institutions in some way. So like, even though Demetrius is just one person, he has been wronged by a system, and so there has to be, now, to be clear, engaging in epistemic reparations is something that I think we can do even if we're not the state. And I have a whole theory about why that's the case, okay? But I think that there's a difference between epistemic reparations and what we might call epistemic repair. Epistemic repair would be the reparative work we need to engage in for the wrongdoing in question. Do I think that there is like a whole paper to be written on, for instance, flat stories online, hashtags, the labels that we use, you know, the character limit on certain sites, right? That in a way force us to tell flat stories about people, right? Absolutely. I mean, I might write that paper, I might not. It just depends on, you know, what I want to do when I finish this. But I want this book to be 5 chapters. I want it to be within the framework of gross violations or injustices, and I am understanding epistemic reparations as quite literally being a politically and legally weighty notion that would be something that would fall out of an ordinance, quite literally. Do you know what I mean? You know, Chicago, I have a multi-year project where we're actually practicing epistemic reparations. So we've done work in South Africa with apartheid era survivors, you know, of violence, and in Canada with residential school survivors. And the work we've really centered in Chicago and Evanston is with survivors of carceral injustice. And one of the reasons why those 3 places were chosen as really important for the project is because there was a very important truth and reconciliation in South Africa and in Canada. And Chicago and Evanston are both historic in the United States. So Chicago was the first city to pass a reparations ordinance for survivors of police torture. And Evanston was the first city in the United States to pass an ordinance for housing discrimination against Black Americans. And so both of them all 3 of those places have very politically and legally weighty, you know, are politically and legally weighty spaces to think about these issues from that kind of perspective. But if we're simply talking about like normative issues, you know, kind of apart from that, I mean, I think there's a ton of things to be said here about flat stories we tell about each other, you know, kind of flat stories, you know, are flat stories that like loved ones tell about you worse than those, you know, kind of flat stories online, flat stories in marketing, do you know what I'm saying? I think that there's so much that I could say, but I'm not going to talk about any of that in this book.
Thank you. And a second question, if I may.
You may, go ahead, yeah.
Okay, and so my second question was, and especially since you're saying like I wanted to have this policy aspect to it very much, then yeah, during your talk I was thinking, well, it's not just that there's this epistemic harm against Dimitri or but it seems that there's also this, you pointed out, this very general misunderstanding of people in the US about the success of the legal system, right? They think we get right convictions because people say that they're guilty. And it's like the whole idea that the US legal system is working is also this false narrative that every one of those individuals feeds into it. So I was thinking, do you also focus on that social level, or are you staying with the epistemic reparations?
So I focus very much on the social level, but I actually really like that. Do I have to stay plugged in for the Zoom? I guess I do, because I would like to take some notes. But that's okay. I mean,
We'll find a way. Yeah, so ideally I'll just turn mine. They can still hear you. So you can plug out.
So I mean, what I really like about, so I talk a lot about collectives. I mean, in the book. So I think that like almost everything I say about epistemic reparations, the right to be known, can go both ways. It can go the way of individuals on one side, you know what I mean, and collectives on each side. Do you know what I mean? What I really like about the question that you just posed that I didn't really think about was, I mean, I say things in this neighborhood, but I like the idea of the false narrative of the criminal legal system kind of being itself a narrative. Do you know what I mean? I mean, of course, I say all sorts of things about like how they demand the narrative here, you know, at the end before you exit, that they extract it from you here to preserve the legitimacy. But I don't think that I say anywhere that like that in turn then is, you know, kind of perpetuating this narrative, creating this narrative. Do you know what I mean? I'm sorry, what was your question? I liked that I just liked that point.
Yeah, I think, yeah, so I was the question was the social aspect. Is that some reparations only targeting the individual?
No.
Or is it
No.
also this bigger narrative that should be repaired, right? Or that stands in need of kinds of reparations?
Right. So there's two things I want to say. So reparations for sure, like I do a lot, I look at Truth and Reconciliation Commissions all the time, which a lot of people think are really looking at residential school survivors. Do you know what I mean? So a lot of like the report from the TRC from Canada is very clear about restoring the status of residential school survivors and then documenting the lived experiences of individual survivors. So a lot of the TRCs are very clear about having those two different goals, right? Collectively doing something for this group of survivors, but then also providing space for the individual to kind of, to bear witness to the individual to have people bear witness to the individual experience and that sort of thing. Yeah.
Jennifer, you can plug out if you want to.
It's okay. I'll just try to remember these things after. Yeah, it's fine.
It's recorded, so you don't need to.
Okay.
Sharing the screen, take notes and stay locked in the Zoom.
But don't worry, I'll send you the recording.
Okay, perfect.
So
That's
you
good.
have all the questions.
That's good.
Right, Jeroen is next. Oh, and then Chris. Yeah, right.
Thanks so much, Jennifer. This was incredibly profound. I wonder if you can say anything. Oh, should I speak up?
There you go.
Yeah, all right. All right. I wonder if you can say more about standards of correctness for these counter stories and rounder stories.
Mm.
And especially, so, I mean, it is like an obvious one for the counter stories, right? We need the falsehoods correcting. So that's clear. But for the rounder stories, that's going to involve some sort of weighing of all the different things that people do in their lives. And how do you do that in a correct way? I mean, is there like a standard for that, or multiple standards for doing it?
Yeah. So what I say in the book is, I don't know if I have anything that I would say is like a standard of correctness, but what I point out are the features of the flat story. So one-dimensional, static, psychologically simplistic, agentially closed. Okay. So the rounder story has to target one of those, or rounder. So when I first started working on this project, I was calling it round stories. And then I immediately took that out because I don't think that, like, what is a round story of my life? I mean, what, you know what I mean? Like, so it's rounder. We're always, I say in the book multiple times that nothing I say in this book is going to be one and done. Nothing. I provide no necessary and sufficient conditions, none, because it's a process. Epistemic reparations is a process. Providing rounder stories is a process. They are rounder. But in order to be successfully epistemically reparative, they have to target one of those things. So it's weird. I've been working on these ideas for a while, and I mean, you grow every time you give these, you present this. So it was just, I don't know, a few months ago, I presented this. I forgot even where it was. And it really forced me to kind of clarify that, like, a lot of the classic examples I give in the book are positive. And someone just flat out asked me, are rounder stories always positive? Right? Because I'm like, William Peoples is like a published author and a this and a mentor and a visionary. And it really forced me to kind of take a step back and to kind of be much clearer that, when you think about round stories in literature, they often have a psychological complexity that is not just singularly good, right? So I give examples now in the book of talking about how incarceration may have led to William having an estranged relationship with his daughter. But you learn that he's a father. You learn that he had a relationship with the daughter. You learn that incarceration is impacting him. These are all part of a rounder story. It's not just like you are just at your core a murderer. That's it, just a murderer. No, he's a father. He's got complicated relationships. He's got desires. And so I think a rounder story that's reparative has to kind of repair that original, some of the original wrongs.
That's helpful. Chris. Next.
I mean, I thought this was wonderful.
Thanks.
Looking forward to the book.
Me too. I'm ready for it to be done.
Yeah. So I wanted to ask about, whether you thought anything about how misknowing, might it be applicable also just to one's own self? So like contributed by, very large and powerful state narrative that they are kind of dominated by in this, terrible moment of their life. And then I was just wondering if you've even maybe met anyone who sort of initially was thinking of themselves like, I was just a murderer, or I was just a rapist. And it takes them a while to kind of unweave this, the narrative, right, that was pushed on them, so that they have sort of like kind of, I don't know what to call it, self-misknowing or
Yes,
mis-self-knowing or
absolutely.
something like that? Just-
Absolutely.
yeah.
Yeah, so yes to both of those. I only recently, I think, got this question for the first time. Michael Bratman actually asked it at Stanford recently, just flat out, like, can you misknow yourself? And I don't think I had gotten, like, I don't think I had conceptualized it exactly that way prior to that question. And yes, I think absolutely. And I think that one of the things that's really interesting is because the work that I do with incarcerated people is the program I run is very competitive to get into. So we get hundreds of applications a year and we only accept 20 out of hundreds. And so by the time people end up in the program I direct, they're oftentimes like years into their incarceration. And I mention this because I think that they are on their road to recognizing that maybe they are not, many of them, not what the state told them that they are. Do you see what I mean? But it takes time, for many people, not everybody. You know what I mean? A lot of people just are like, I'm not what you're saying I am, but there are many who believe it. One of the things that's really interesting is that there's empirical evidence that shows that if juveniles have contact with the criminal legal system, it starts to shape how they think of themselves. The impact is almost like they think of themselves as a criminal. And that contact with the juvenile criminal legal system then has tremendous impacts on their self, the possibilities that they think are open to them, the choices that they make eventually. And so, absolutely. I mean, I think that there's not only do I know people in my own life for whom that's true, but I think there's lots of empirical evidence that shows that that contact with some of these systems directly leads to a sense of misknowing oneself. Mhm. I'm not being rude. I'm taking notes. Sorry. I just decided I'm taking some notes here. Go ahead, but I can listen.
Yes, thanks. So I was interested a bit more in the group of incarcerated people, and especially for example, the concepts that you develop, the theories that you develop, lifestyle stories, router stories, the counter stories, how you present those in the program, and also if they change based on what you learn in a program together, how that sort of interaction goes, or if it's like an iterative process where the theories also grow based on.
Mhm. Yeah. So I think it's like really kind of a really organic sort of process, meaning that I think so I share the chapters of my book with all of my incarcerated students, and they are invited to give me feedback. And so William recently read the chapter where I discuss him a lot. And, I, of course, get their consent and make sure that they're happy with everything that I say and comfortable. William has talked very publicly about his story, and he has published a story in the Northwestern magazine about it. So I cite it in the chapter so that there's a public record. And I'm also like it's very important to me that I'm not telling anybody stories. This is not a book where I'm telling stories. This is a book about stories.
Mm.
Do you know what I mean? I'm a philosopher. I'm a scholar. I'm an academic. I'm not, they should tell their own stories. You know what I mean? I don't want to tell their stories. I want to provide an educational program that gives them the tools and the opportunities and the platforms to tell their own stories. And so I direct a program where we have tons of professors. I mean, it's a full-time college program with 150 students in it. And so, when we do our training for professors and tutors and undergrads and graduate students, one of the things that I always say is, we're not going in there to expose the conditions of the prison or to do anything like that, because the students do that really well. They have articles and they write op-eds and, And the reason I say that is because I think that, I have, because of my orientation as a philosopher, I have a certain way of looking at things that people who are living incarceration or living a wrongful conviction or in the criminal legal system as a lawyer don't have. And then now that I'm so immersed in this world, I now have experiences with people that I think enable me to see things that I didn't see before. So let me just give you one example. I met Demetrius a long time ago. And I remember being immediately struck by the fact that despite the fact that like I'm the editor of these two journals and I receive, I can't even tell you how many submissions in epistemology on some form of epistemic wrongdoing. I had never come across an account that explained what happened to him from an epistemic point of view. It was clear that something had happened to him epistemically. Do you know what I mean? It was clear that when you have testimony taken from you, right, and then presented, I mean, of course, we all know he's wrongfully convicted and he's wrongfully incarcerated, and those are gigantic wrongs that he's suffering. But there was something about the interrogation process that was distinctively epistemic. And there was nothing that got at that. There was just nothing in the literature. So that's the kind of space where I feel like I can occupy. Do you see what I'm saying? I'm not telling Demetrius's story. Demetrius should tell his own story, and we give him lots of platforms to do that. He just recorded, I mean, you know, for those who want to stay later, I can play it for you if there's sound on here. He recorded like an incredibly beautiful story. I mean, an incredibly beautiful song. He's a beautiful singer and songwriter. He taught himself to play the piano on a cardboard piano that he made, keyboard, in his cell. But what I think I do is I am able to use my expertise and the tools and training as a philosopher to analyze phenomena that I think kind of fall through the cracks because lawyers aren't really doing it because they're not philosophers, and people who are, you know what I mean? And so.
So when you presented these reactions back to Demetrius, how did you respond?
I mean, people respond to me. I mean, I think for him, it was liberating. I think he felt seen. I mean, I think one of the, I didn't even like fully grasp myself how much this book is a sister book to the last book I wrote, because the last book is all about the state stealing people's stories from them. And I see this book as trying to give people their stories back. And I think that Demetrius had felt very invisible and not seen. And I think that naming what had happened to him, he felt seen. But then, you know, like William, when I gave him the chapter, he gave me, I mean, extensive written feedback. But powerful things that are, you know, I now include in the book, and of course cite him and attribute to him. And, you know, like one of the things he wrote me like a 3-page letter and said that, you know, as much as he has a flat story told about him, his victim has a flat story told about her. And he talked about how pernicious that is, that she is just a victim. And that in the criminal proceedings, we lose sight of who she is and how important it is to tell a rounder story about her. And it's a beautiful addition to the book, I think, that it came from him. And so, yeah, all of my chapters go back inside. And I treat them like I would any of my colleagues, you know what I mean? Like, you know, give me some, you know, if you want to give me some written feedback, you know, like, go for it.